I've been asked to lead off the presentation, and I've probably got the distinguished opportunity to present on something that's probably the least lofty and philosophical, although I'm going to do my best to go there with you, of anything. Basically, I've been asked to give a dispatch from the front lines of the spam wars. That's litigation, that is, against those who would be clogging the digital commons for purely private gain, and by fraudulent means, I might add. I realized today, listening to everyone speak, I've done all kinds of different litigation, and the one kind that I really wished I had been able to get to in my career, and I haven't, is environmental law. And today I realized I'm an environmental lawyer. And that is because if we take the digital commons as part of the commons, which obviously I don't need to make that case anymore today, that's been done quite eloquently. I guess what I do and what I've done for the last 5 years is try to basically fight the polluters, clean up the pollution on the digital commons. Now, I can't think of any more intimate part of the digital commons, so to speak, than our emails. I probably wouldn't get much disagreement there. I think that when we open our email programs, we expect privacy, and it's gotten to the point now with the growing use of email and choice as the mode of communication, I would submit, in most developed, or as I like to say, overdeveloped societies. But in any event, certainly in our culture, we expect a heightened degree of privacy and intimacy, even with the kinds of communications which we share on email, which basically is everything, I would imagine. At this point, we send love notes and love letters, and we send business transactions, and we send organizational information, pretty much every type of communication that one personally can enjoy. We send out on our email, and we tend to, and I think rightly so, we have an extremely high expectation of privacy, through that medium. But we don't always get it, although it has been getting better. There are those who, for private gain, would invade that space, and there's two aspects to this. There's obviously the personal and intimate nature of email. That's the personal, I guess we could call that the personal access to the commons through email, that is. We also have our browser, of course, but that, I don't think that that's quite the same as in terms of the intimacy we expect. We don't have that relationship with our browsers, but with email, we expect it and we want it. And for years, ever since the internet has gained prominence and email has gained prominence as the mode of choice of communication in our modern society, we've all been barraged by all kinds of advertising polluting that space or that part of the commons, our very personal part of the commons. It's gotten a lot better over the last few years, and most of you probably have noticed that with the advent of, there's been a battle going on behind the scenes in the technological world, which is, some people working to filter the email, and then people working for the spammers that are trying to beat the filters, and that battle rages on and goes on behind the scenes. And a lot of the current spam filters and email filters are, pretty reliable, but I venture to say that most of us still occasionally see some spam popping up on our emails now and then. Well, a few years back, someone asked me, it was actually a local anti-spam activist who had been bringing these small cases against spammers more based on this sort of invasion of personal privacy issue. But, you know, he needed a lawyer. He wanted to sort of take it to the next level, so to speak, and he was getting beat up quite a bit in court as a pro se litigant, as pro se litigants tend to do sometimes. And I agreed to help him out, and that was my introduction into the world of spam litigation. And as an aside, and to dispel some myths that have been circulating, I will say that yes, I have taken the deposition of spammers, even penis pill spammers, and I have asked penis pill spammers under oath whether they ever use their own products. And they have told me under oath that they have, and this is after assuring me that, when I asked how did you come up, you know, what goes into your product, and this is a product, of course, that these people were recommending to millions of people on a daily basis to put into their bodies. When I asked what pharmaceutical and biological research did you do to determine what went into these pills, and this person assured me that he and his partner did weeks, if not an entire month of research on the internet to find out exactly the right chemical and herbal mix to put into these pills that he was recommending millions of people take. So that assured me, of course, that there was no case there, at least not for fraudulent advertising or anything like that. But in any event, he tripped me up when under oath I asked, what were the results of you taking your own product? I had to ask that, right? And he said, well, you'll have to ask my wife. And at that point, I realized that the spousal privilege pretty much would cut me off from any further inquiry. And so that ended that part of the discourse and that part of the deposition. But on a more serious note, okay. So the question then becomes, there's always going to be a balance. How much advertising can we and are we willing to tolerate in the commons? You know, there's been litigation and there are laws that regulate billboard advertising. And probably most people here, if not all of us, are thankful for that kind of, those kind of laws that would sort of limit our exposure at every moment to advertising, because we know that there are those who would expose us at every given moment to advertising if they could. The trick here, of course, is, and the bottom line of consumer capitalism is driving eyeballs, as they say, to your product. You've got to get in front of somebody to sell it. But that reminds me of a quote that I've always loved, and I read it in a book by Jerry Mander, and I'm not sure if he said it, but he used it, and he may have said it, which goes, I've never seen a product that I really needed to be marketed. I think we need to think about that, because people do tend to find their way to products that they really need. And so the entire industry of marketing, advertising, the billions, literally billions of dollars spent on Madison Avenue and by corporate America to put these products of all kinds. We're mostly familiar, of course, with TV commercials that just drone on and on and on. And in any given show, you'll see the same commercial, you know, 3, 4, 5 times. It can't get much more obnoxious than that, except I submit that every time when you open up your email, if you have to look at ads for products that you don't want, don't need, you know, have no use for, and potentially, and in some cases actually, if you probably know this if you haven't experienced it, that when you open some of these emails, they actually have viruses and web bugs and all kinds of nasty things and spyware that embed themselves into your computer to record your clicks for other commercial interests, and you record your browsing and other kinds of behavior. In any event, the dispatch is that it's been a mixed bag. The federal law, the Can-Spam Act, it's called the Can-Spam Act of 2003, was only recently enacted. It was actually enacted in 2004, even though it's called the 2003 Act, which many of you may remember was under the quote-unquote do-nothing Congress. And they essentially did pretty much nothing by enacting this law. It's a law that's fairly complex and fairly complicated and convoluted, and it's just wrought with loopholes, and it does anything but, you know, sort of stem the tide of spam. And then states have followed suit, and most states have consumer protection type anti-spam laws connected with their Consumer Protection Act, as we do in Washington State. It's called the CEMA Act, and it's at RCW 19.190, and it's a much simpler act. It's only about 2 pages long, and you can actually read it and understand it. But we've run into problems now with preemption issues in federal court, and there's all kinds of issues, as you may expect, in interpreting these kinds of laws. And the judiciary has been surprisingly perhaps, I mean to some, but maybe not to others, surprisingly the judiciary hasn't been anything but very friendly to the most of the spam cases. And when I say spam cases, I mean the anti-spam cases. And you know, they've sided with a lot of the corporate spammers, so to speak, on a lot of issues. And so now we've got basically what we have now is we're waiting for decisions from the Ninth Circuit Court of Appeals on several different issues that we've had to litigate, and I don't really have time to go into in my written materials, which I believe are on the DVD, there's some more details about the technical aspects of this and what are the sort of the statutory interpretation issues. You know, everything from standing, as we've been tossed out of court as the little guy, and in the Western District here in Washington, we've been thrown out of court with an interpretation that basically says, well, Congress couldn't have intended for little ISPs or internet access services to actually benefit or use this statute. They clearly had the large ISPs, the large corporations in mind when they wrote this. There's nothing, I can assure you of that, there's nothing in the statute that has any size limit on who can use this statute, but that's the current interpretation in the Western District of Washington, that you have to have what's, you know, sufficient damages is what they're saying. Because, okay, so let me just go back to a couple more of the limitations under the Federal Act, the Can-Spam Act. The Can-Spam Act has no private right of action for individuals. So you as an individual cannot sue in court for the receipt of spam under the Can-Spam Act. What it does have is it has a limited right of action for internet access services. Most people, and there's a whole technical you know, interpretive body about what that means, but basically it's an ISP, an internet service provider, somebody who allows access to others to the internet. Now we all know that Yahoo, AOL, Earthlink, Google, you know, those are the familiar names that, you know, have 99% of the market in that area. What people don't realize probably is that even though you're not, or we're not getting the spam on our individual accounts that much anymore, let's say as much as it used to be, spam has actually increased exponentially since when you were getting much more spam. So where does it go? Well, where it goes is onto the servers of the ISPs. Now the large corporate ISPs, like the ones I just mentioned, can obviously absorb those costs, you know. 10 million, 50 million, 100 million, buy some more servers, throw some more technicians and technology at it, and just deal with it. You know, build it into your costs, build it into your infrastructure. What's actually happened, though, in the real world is that most of the mom and pop, and you may have noticed this, where did all the local small ISPs go? How come I can't easily get an account at, revolution.com or, progressivelawyers.com or anything like that? Now, there are still some. I'm not saying that they've been wiped out. But the consequence of having to deal with that kind of barrage of millions and billions of spam, that kind of flow, has actually driven most of the small size and even mid-size ISPs out of business. In Washington, the vast majority, in our state, and I assume that it's true around the country, have been actually driven out of business because of the costs associated, the infrastructure costs associated with dealing with spam. Buying servers, technology problems, just all the problems that come with having to manage that kind of flow. Just couldn't do it. With that said, I know you're really dying to hear more about spam because you love it so much, but my time is up. And I'm going to introduce Brian Rowe to you. Thank you.